My lords, the contempt notices I've got, I will strongly object, my lords, to this. My lords may record my objection and dismiss my application.
No, I am not dismiss it. I'll hear it along with the contempt.
My lords, I am objecting to that.
So I will note your objection and then.
My lord may first hear me. At least that much. Today the councils are appearing. Today the councils are not on strike.
Merit पर तो दिया तो contempt में.
Merits में मैंने खत्म ही नहीं किया, sir.
अच्छा चलिए बताइए.
There is a lot which remains on merits.
हाँ बताइए.
नंबर 2.
This is a repeat application for the grant of bail, my lords. The offender is one Sangepu Chakradhar. Offences, my lords, are under sections 379, 120B, 420 and 30. The main accused person in this case, Mustaqeen, was granted bail by the Honorable Apex Court. Thereafter, I'll take my lords, may just bear with me. Mustaqeen bail applications were rejected by this honorable court. In fact, no bail applications were allowed. The co-accused persons and Mustaqeen's. In the month of November, Mustaqeen's bail application came to be rejected on merits. Mustaqeen challenged that order before the Apex Court and he got a favorable order from there. Now, there were about 3 aspects which weighed with the Honorable Supreme Court while granting bail to Mustaqeen. If my lords will just have the order of the Supreme Court, my lords. That is on page 26 onwards. May I read from the top of page 27?
As you like.
Thank you. Learned counsel for the state, with reference to their objection statement, would contend that the trial is in progress and therefore there is no cause to release the petitioner on bail. However, having taken into consideration the said aspect of the matter, we also note that the petitioner has been in custody for about a year, and the other co-accused have already been released on bail in the connected offences. In any event, the petitioner is required to diligently cooperate in the trial. If the petitioner fails to do so, it will be open for the respondent state to bring the reluctance on the part of the petitioner to the notice of the concerned court for appropriate action in the matter. Now, these were the considerations, largely. Consideration number 1 was most certainly that Mustaqeen had served about 1 year in custody. And consideration number 2 was that all the other co-accused have been released on bail in the connected offences. Now, it is a parity on two parts. Now, after this order came, every other co-accused person approached this honorable court, and this honorable court was magnanimous enough to grant bails to Sohrab, Musa and Farman, on the ground that it is non-distinguishable from the case of Mustaqeen. And allowing the doctrine of parity, my lords granted bails to those persons. Now, this application came to be considered last. Wide order dated 21st of March 23. That is on page 28.
Page 28. Yes.
No, I'm sorry, that is the co-accused person's bail order. This accused person's bail order, my lords, is on page 34 onwards. Page 34, this was on the 27th of March 23. None had appeared on behalf of the present applicant. What had happened on this day, is that 2 matters were listed, the present applicant's matter and one Farman's matter was listed. Now, Farman's matter, his brother had appeared. Farman was, of course, he had parity on both counts. That is why my lords heard the matter and my lords passed orders allowing Farman's bail application. Owing to the fact that they were clubbed together, I presume my lords also took up this matter and passed these orders. But my submission would be that none had appeared for the applicant in this matter.
So who stopped the persons appearing for the applicant?
That was out of the council's own volition, my lords. That was out of the council's own volition.
Then,
the court is not to blame.
How can court be blamed?
I'm not blaming the court.
Then why you are arguing this aspect?
I am saying that the representation to the applicant was not there.
Is it necessary that when case is listed, court should wait for the parties to appear and should wait that lawyers who are illegally striking and abstaining from work should be allowed to return back?
That will be a very objective answer on my part, which will have nothing to do with the facts of the case, so I'll refrain from answering. If off the record, my lords, is to a question, I would like to answer that, but not during the fact.
The court has already held that such calls by the Bar Council or the Bar Associations are illegal. Then
there is a division bench order of even our High Court which says that lawyers going on strike does not amount to contempt.
Yes.
There is a division bench of our High Court prior to the
And in
suo
this
motu
case
registration.
also I had issued contempt notices.
Yes,
Yes. I don't know
Whenever-
who was the counsel. You
I
were
was the
there?
counsel.
Oh, you were the counsel.
Whenever
Yes.
those notices come to me, I'll
So
choose to reply.
let us list this case along with the contempt notices. Then we'll hear it, this case.
Well, as the contempt notices I've got, I will strongly object, my lords, to this. My lords may record my objection and dismiss my application.
No, no,
I
I'll
am
not
making,
dismiss it. I'll hear it along with the contempt.
my lords, I am objecting to that.
So I'll note your objection and then.
My lord may first hear me. At least that much. Today the counsels are appearing. Today the counsels are not on strike.
मेरिट पर तो या तो contempt में
Merits में मैंने खत्म ही नहीं किया, sir.
अच्छा चलिए बताइए.
There is a lot which remains on merits.
हाँ बताइए.
Now, my lords, once this application came to be decided by my lords only looked at the aspect of parity from one point of view, as to whether the custody period is similar to that of Mustaqeen or not. Now, my lords, giving a finding, my lord said, after the notices of contempt were issued against me, my lord said this is the first bail application on behalf of the applicant Chakradhar Sangepu in relation to crime number such and such registered at police station for offences punishable under section 379, 120B, 420 and 34 of the Penal Code. Applicant is in custody since 19/10/22. Counsel, learned government advocate submits that the present applicant Chakradhar Sangepu is the main accused. He is the kingpin. He was evading arrest. He has recently been arrested. He was operating a gang. Honorable Supreme Court has granted benefit of bail to one of the co-accused persons, observing that his custody period was over 1 year. In the present case, the applicant's custody is of recent origin and his custody period is not over 1 year. Therefore, there is no parity. Now, Millets, what I submit is that the Honorable Supreme Court had granted parity on 2 counts. The first count was that all other accused persons in connected offences have also been released on bail. Now, if my lords will only permit me, I would like to just dig a little deep where that aspect of parity is concerned. Now, Millets, when the Honorable Supreme Court says that all other co-accused person and the present applicant as well have been granted bail in connected offences, what would be the legal implication, my lords? Now, including the present applicant's case or including the instant case, there are 4 other matters pending against the present applicant as were pending against all the co-accused persons. Those were Sohrab, Mustaqeen, Musa and Farman. They were taken into custody earlier in time. Now, Millets, in the instant case also, Sangepu was taken into custody later in time, but for all similar 4 offences. Now, Millets, in all those matters which are not this offence, Sangepu has already been granted bail. Now, if my lords will just see, I have filed those orders. Those orders are on page 37 onwards. Page 37, my lords, this is Sangepu's bail order passed by the Learned District Sessions Court itself. And on order dated 5/1/23, he has been enlarged on bail. Thereafter, my lords will see page 41. This is of another offence registered at Sivni, all arising out of these same connected offences, we may call them safely. Bail was again granted, my lords, in this offence. White order dated, it is 14th of January 23, my lords. Now, my lords, what I submit is that when we look at the operation of these orders, although bail has been granted, personal liberty in these matters of the present applicant stands secured. He will not be able to reap the benefits of those orders just because he is not being granted bail in this case, my lords. That, I humbly submit, my lords, can never be the intention of the court. Similarly, my lords, what has weighed with the Honorable Supreme Court is exactly that. When the Supreme Court was faced with a situation that in all other connected matters, when all other co-accused persons and the present applicant has already been granted bail, then why will the present case only be that one case which does not allow him to be set at liberty? Now, Millets, coming to the doctrine of parity. Millets, the doctrine of parity, or I may humbly submit, Millets, almost any doctrine is of general application. Let me take another doctrine, Millets, as an example, that is falsus in uno, falsus in omnibus. They say that it is mechanically not applicable in India. Now, that is a very general term, Millets. Whenever we talk about a doctrine, it is implied within the word doctrine itself that there is general application to it. Now, Millets, the question which would arise before my lords is, can a legal proposition which is of general application have a pedantic approach to the application? I, Millets, would like to answer that question with a very unequivocal no. Because something which is of general application, something like the doctrine of parity, cannot take a very pedantic approach towards its application. Now, Millets, here we have a case in which the nature of allegations against both parties, against all parties, in fact, are identical. And I would say that against Mustaqeen and Sangepu, they are almost identical because they are both arrayed as accused in the nature of conspirators. There is no direct evidence against Mustaqeen or Sangepu. Mustaqeen, at the point in time of the offence, was said to have been by the prosecution in Pratapgarh. Sangepu was said to be at the time of incidents at Andhra Pradesh. The persons committing the offence, all three accused persons have already been granted bail, who the prosecution story was that they were present on the spot, in fact stealing the cars.
Yes.
Now, what I very humbly submit, my lords, is the doctrine of parity, if it is just whittled down or just reduced to one simple point of factual distinguishment, that would go against the doctrine of parity, my lord. And especially in a jurisprudential system where we accept two things, my lords. Number one, that there is nothing more important and beyond personal liberty. And number two, where we believe very strongly that bail is the rule and jail is not. Now, when we take these principles in mind and we see the doctrine of parity, I believe, my lords, even my lords would concur with me to some extent, whether or not it reduces itself to the order or not. But there will be a certain sense of concurrence that the doctrine of parity is to be applied with generally, and I would not say leniency, but with some amount of enforcement of this rule of bail is the rule and the aspect of personal liberty.
Right.
Now, my lords, under these circumstances, I pray that these same arguments which were raised before the Honorable Supreme Court are still available. Mustaqeen and all millets were taken into custody in the month of March 2000.
He is the mastermind of the entire story. First, the date of arrest is 2010 of 22. Second, 20-10-22. थर्ड इससे जब हुआ इससे 3 नंबर प्लेट
19-10 कैसे लिखी है आपने एप्लीकेशन में 19-10 कैसे लिखी है
डेट ऑफ अरेस्ट 20-10
20-10 is the date he was presented before the magistrate.
अरेस्ट मेमो किस तारीख का है
गिरफ्तारी 20-10-22
I'll just look.
आपने गलत डेट लिखी है दूसरे अपराधों का अरेस्ट
इन क्राइम नंबर 26 ऑफ
हाँ
20-10 है सर. As per the arrest memo,
तो करेक्ट करिए पहले तो एप्लीकेशन को डेट पे देखेंगे
I'll correct it.
there is a incorrect omission of the date of arrest of the applicant as 19-10-2022. Shri Nitin Gupta, learned deputy government advocate, points out that the correct date of arrest is 20-10-2022. Applicants may move in appropriate applications for correction of the facts listed thereafter.
Ever so obliged me.